All right. I want to start out, as everyone has, thanking Robert, thanking the journal. Appreciate the opportunity to be here. I do have a confession to make, which I have already done to some of you. When Robert started out his talk by describing how there are faculty members who write one article about franchising and then go do other things, and I was like, oh my God, he's talking about me. Because I write about arbitration. I'm not a franchise. I mean, I sort of know about franchising stuff in connection with some of the work I've done on arbitration, but I write about arbitration. That's my area. And I've done some stuff with franchising and have come back to franchising, but have not consistently written about franchising. And my work on arbitration, I guess I would describe as having an important empirical component to it, not just reading cases or describing cases, but actually looking and seeing what people do either in their contracts or in arbitration proceedings. And if you think about it for a minute, that's a little bit of a challenge for a researcher, right? Because if you're looking at arbitration clauses, you're looking at contracts. And you don't want to just look at sort of pre-selected or atypical contracts. You want a broad sample of contracts so you can get a sense of what the world is really like. And contracts aren't typically public documents, okay? And if you want to look at what happens in arbitration proceedings, you can't just look at the court cases with challenges to awards because you don't know that those proceedings are typical. So you need to get a broad sample of what actually goes on in arbitrations. And those are private proceedings, right? You can't typically find that out. Now, there's some exceptions. But that's really what first brought me to franchising and what were then called the Uniform Franchise Offering Circulars and now are franchise disclosure documents, is their data source, okay? And they're a data source in the sense of all the franchisors have to, as we saw this morning, in registration states, they have to file. And so I spent a summer vacation, it was just a day, at the Minnesota Department of Commerce, standing in front of a photocopying machine, photocopying arbitration clauses of franchise agreements. Way back in 1999, I think it was, which was my first exposure to franchising other than the obligatory eating at McDonald's and so forth. And used it more than once. It wasn't just one article, it was several articles, but it was, again, using franchising as a source of data on arbitration, okay? Now, there's been other opportunities in other fields to use samples of contracts. I was probably the one person in the country who was excited when the Federal Reserve announced a new database of credit card contracts that I've also used. But franchising can provide a way to learn about the process that I sort of know the most about, but I'm most interested in, but have a hard time finding data about. Okay. What I'm going to talk about today is, again, using the franchise disclosure document as a source of data, but on a different part of the process, right? So instead of looking at the contract terms, which I've certainly done some of, probably more than anyone's interested in, but also looking at, to the extent we can, arbitration proceedings themselves, okay, because of the required disclosures of the in the FDD. Okay. And one thing, just as a note, there was discussion this morning also of the role of the internet in franchising. As I said, in 1999, I basically spent a day standing at the Minnesota Department of Commerce, pestering the staff to keep bringing me out new franchise agreements. Okay, now you can just go online and find them, right? There's a Minnesota Department of Commerce has a web page, and you can get the last 4 years worth of franchise disclosure documents. They're huge, right? They're these 500 to 1,000 page documents, which are a pain in the neck to deal with as PDFs, but it no longer requires going there in person. California's actually done it for longer, but the registration requirements in California are such that so many of the bigger franchisors are exempted that you don't get a very good sample. I mean, it tends to be smaller, newer franchises, whereas Minnesota doesn't have those same limitations. But so the work that what this paper is based on and some other things I've done now is easier than it used to be to do, let's put it that way, because you can just get the stuff online. So the starting point here is with the amended FTC rule, right, which requires all these disclosures, okay? And the one I'm interested in is item 3 of the franchise disclosure document, which is the litigation disclosures, okay? And there's 4 things that franchisors have to disclose. They have to disclose if there's a pending material civil action, okay? And it's either one that's related to antitrust, securities, franchising law, or otherwise material. So that's one thing that they have to disclose. They have to disclose that when they were a party to a material civil action involving the franchise relationship, which typically means the franchisor suing the franchisee or bringing a claim against the franchisee. They have to disclose anytime in the last 10 years they have been found to be a party or held liable, in a civil action involving franchise, antitrust or securities law, and so forth. Okay, and then they have to disclose if they're subject to a pending or currently effective injunction. Okay, now even that description, I mean, there's limitations in these disclosures, I will say right off the bat. Okay, and that's something, one of the important things I want to talk about as far as, again, from my perspective, a source of data. All right, I mean, clearly the idea here is not to help researchers who can't otherwise find out about arbitration or who can't find out about arbitration clauses. Right, the idea here is to provide information to the franchisee that's relevant and important to the franchisee. From a researcher's perspective, there's definite limitations, right? So if the franchisor has been held liable in the last 10 years, it has to be disclosed. Well, if they win, it doesn't, right? Because they haven't been held liable, okay? Or if it's material action, it has to be disclosed, but not if it's not material, okay? And it may be that different franchisors have different standards or because of different sizes. I mean, maybe it's their own interpretation, maybe it's because they're differently sized. But the definition of materiality may vary across franchisors. Okay? So there's limitations even just up front in what has to be disclosed if what you're trying as a researcher to do is get a big, sort of the whole picture of what's going on in franchise dispute resolution. Okay. Now all right, why is this not working? The FTC rule defines action, and this is sort of this definition, frankly, is is helpful for me because action doesn't just mean court action, it also means arbitration. Okay, and arbitration proceedings aren't something you can usually find out about, right? I mean, if you want to find out about court actions, at least federal court actions involving franchises, you can go to PACER, right? There's a database of all federal court filings. It's a pain in the neck to deal with. Law professors can now get free access to it through Bloomberg Law rather than having to pay the usual however many cents a page. So you can do it, but it's hard to do, but at least the stuff is public, okay? Unless you actually enter into a confidentiality agreement with the AAA, who's turns out to be willing to let you have access to their own files, there's no way to find out about what's going on or whether in fact there even are arbitration proceedings involving franchisors and franchisees and others. Unless other than this data, frankly, right? So these disclosures give a unique, as far as I'm concerned, source of data, subject to all kinds of limitations on what goes on in arbitration. Okay. In addition, so the definition of action, boy, that's not working now, is a broad one. I already mentioned the issues of materiality, okay? That it's actually not a defined term in the FTC rule. Other than to say, well, we're the FTC, we know what it means for something to be material because we use this standard all the time. It's what a reasonable prospective franchisee standard that they've adopted. But what I'm going to ultimately look at are franchisor-initiated actions. So when the franchisor brings an action against the franchisee, and there actually is pretty extensive commentary or relatively extensive commentary on what materiality means in that context. And pretty much what the FTC says is basically every one of those actions, with some possible very minor exceptions, should be deemed material. So it's important for franchisees to know how litigious the franchisor is, either because that may show lots of problems in the franchise system if you've got lots of litigation going on, or conversely, it may show that you have a very active franchisor who tries to keep the franchisees in line, however you want to interpret it. But regardless, the extent of franchisor-initiated action is a material fact, unless it's I mean, the one example that the FTC gives is if you have a franchise on a military base and you've got some special rules governing it, maybe you don't need to disclose all those in your standard franchise disclosure document. But as opposed to the cases where the franchisor is being sued, where you're subject to this materiality standard, which may mean stuff is being left out that, again, from a research perspective, would be really nice to know about, that shouldn't be as much of a problem, one hopes, for franchisor-initiated litigation, which is what, again, ultimately I'm going to focus on. Okay. What do you have to disclose? Actually, quite a bit of information about a case when it is the franchisor being sued or being brought to arbitration, right? The name, case number, filing date, summary of legal and factual nature of the claim. Interestingly, I guess another thing that you can't otherwise get access to is settlement information is supposed to be disclosed. Okay. And again, even court filings wouldn't necessarily tell you what the terms of settlements are. So this is another case where you can actually have a unique source, potentially anyway, of data on litigation processes and outcomes involving franchising. Okay. And I'll talk more about this later once we get to what I'm actually doing with this data in this case. But now, that's for when the franchisor is the defendant. The FTC rule, when it was being discussed anyway, the franchisors didn't like the idea of providing that much detailed information about actions they bring, and so the FTC allows much more summary information there, essentially just identify the case and put it under a heading of what sort of case it is. And so there's a lot less information about franchisor-initiated claims or actions than there is for cases in which the franchisor either has lost the case or is the defendant. Now, this seems to me to be a unique source of data. And what's interesting is that it really hasn't been used, hardly at all, frankly, to my knowledge. And maybe I'm just missing something, but the only paper I know that's even looked at this data is by Jack Dunham and David, I don't know how to pronounce the last name, Hieronymus, and looked at franchisor disclosures in item 3 back in early 2000s, which was before the amended FTC rule, right? So this is actually more than 10 years old at this point, and which means no one's looked at the data that might be available under the new FTC rule. Okay, and so what they did was picked out 30 large franchisors and looked at all their item 3 disclosures and found 420 cases that were disclosed. And then going through those 420 cases, they basically summarized all the information that was there. And that's really all they did with it. But even that's, again, they're the only ones who've even done that. Okay. And so they found various things, right? So this gives them some information about outcomes in franchise, in disclosed cases. I probably should be precise and say that. Okay. So most of them settled. There's no surprise. 16%, so 71% settled, 16% were resolved on motions, leaving the remaining 12% decided either after bench trial, jury trial, or arbitration hearing. Okay. The cases that were identified as arbitration proceedings, 60% went through the whole hearing to an award, whereas if you were in court, it was 10 and 8% respectively, federal and state court, resolved by trial. That's actually very consistent with virtually everything I've seen on arbitration versus court, right? I mean, we all have a sense most court cases settle, okay? Most arbitration proceedings, at least once they are filed, do not settle. Or maybe most do, but a much larger percentage of arbitration proceedings go through the whole hearing and are resolved with an award rather than settling. And there's various reasons why that might be. I mean, there's not formally the same sort of motions practice, although informally it's becoming more common in arbitration. It may be that arbitration's lower cost, and so you don't have as much discovery expense, and so people are willing to go through the whole thing. It may just be there's a lot more uncertainty about what's going to happen after the arbitration, right? And if you can't predict what's going to happen, it's really hard to settle. So there's various reasons why that might be, but this finding of theirs is consistent anyway with what other studies have found about sort of how far a case goes if you're in arbitration or in court. And then they actually had reported results about how the cases came out. And what they found was that, and these are just the sort of whole wins, there were sort of complete wins, partial wins for the franchisor, and then complete losses for the franchisor. Franchisors, by their study, did, and I should probably say this just to be clear, I'm trying to be very circumspect in how I describe this. These numbers are totally meaningless, as we'll talk about in just a second. All right? I'm just describing the study first, but once we see how they came up with these numbers, there's very little you can do with them. Very, very little you can draw in the way of conclusions from them. So keep that in mind as we're talking about it. But this makes it look like franchisees do a lot better in court than they do in arbitration. Sorry, the other way around, right? Franchisees do a lot better in arbitration than they do in court. Okay, which is probably a little counterintuitive because at least I think the supposition would be franchisors probably prefer arbitration, maybe for repeat player reasons, maybe for otherwise. Okay, at least as far as this is sort of who wins outright. And then conversely, if you look at the average amounts awarded, okay, again, settlement agreements were disclosed. So settlement agreements, arbitration awards, bench trials all had roughly similar average outcomes. Okay, and then you get to your jury trial, it's like 6 times more. And again, that may not be unexpected, right? Because we could see juries, I mean, from the franchisor's perspective, the juries can do wacky things with big numbers. From the franchisee's perspective, the jury can sort of more accurately reflect the sense of the community about what the wrong was done. Again, I think the number's totally meaningless. And I think they sort of recognize, they certainly recognize there are limitations to what they do, but that's at least what the numbers are showing. Okay. Now, people who do empirical work, there's also, I mean, it's really hard to do empirical research on court cases, arbitration, or anything, right? Even if you can get the data, it's hard to know what it means. Okay, and so the usual technique is to describe your findings and then follow it with a whole list of qualifications to show that you're not sort of blindly thinking that these numbers don't have any problems with them. Okay, and Dunham and Hieronymus do that as well. They have a whole list of, this is like most of the article actually, 8 different potential limitations of what they found. Okay. The first question, which is always a question, which we talked a little about this morning, right, is are your findings representative? Okay. Can you extrapolate from hotels to fast food restaurants? Can you extrapolate from the franchises you studied to other franchises? And they pick 30 large ones. If there's reason to think that there's something unusual about those franchises, or if large franchises you would have different dispute resolution results than small ones, you have to be very careful about extrapolating the results beyond the franchises studied. Okay. Problem I've already alluded to is that maybe these franchisors construe what a material piece of litigation or material civil action is differently. Okay. So to some extent, you're relying on a variable you have no idea of, which is how the materiality requirement was construed by the people making the disclosures. That's a problem. The next one is actually the biggest problem as far as understanding the results. So this litigation that's being disclosed isn't all just franchisor-franchisee litigation or arbitration. Okay, so for example, this is a modern example rather than the one that they faced. General Nutrition Center has been subject to products liability suits because people take one of their supplements and die. Okay, those would be disclosed. Okay, and the way Dunham and Hieronymus did the study, they grouped those cases in with franchisor-franchisee disputes. I don't know why, right? It seems to be the sort of first thing you do is you exclude the ones that aren't comparable. But that may be part of the reason why the jury verdicts are so high, right? I mean, if personal injury cases are more likely to go to juries than franchisor-franchisee disputes, and if someone dying has a lot higher damages than a wrongful termination, you'd expect that sort of variation. So this is a huge limitation as far as I'm concerned with drawing any conclusions from their data. But it's all there is, okay? Another limitation that they acknowledge is that, and this is one that's specific to the pre-2007 FTC rule, that franchisor-initiated claims didn't used to be disclosed unless the franchisee had filed a counterclaim. So you had a very limited sample of franchisor-initiated claims. That's now been done away with under the current rule. So that's no longer a limitation of the item 3 data, but it was back then. Okay. As I think I also mentioned before, you don't have to disclose something, right? There's no pending action if the dispute goes away before a case is filed, okay? Which means that, and there's actually discussions, and sort of those of you who practice in the area may well have had experience with this, which I don't, but the possibility of disclosure may affect the likelihood of settlement, and it gives franchisors an incentive to settle before a case is filed, okay? Which can then bias your sample of cases that actually show up in the item 3 reports. Okay, I mean, this sort of selection bias is a huge problem. I mean, settlements causing selection bias is a huge problem with any studies of litigation. Okay, it's a little bit less of a problem in some ways with item 3 data because you have, at least the settlements are supposed to be disclosed. Okay, at least if there is an affirmative payment by the franchisor. But if the case settles before an action is ever filed, that's not going to show up anywhere. Okay, and that may affect what characteristics of cases are filed, and so it may bias your results. Okay, I mean, it's hard to measure who wins or loses. This is, again, an ongoing problem with any studies of litigation and arbitration. A franchisee may win $1 million, but effectively, if they should have won $10 million, yeah, that looks like they won, but actually they lost. Okay, or vice versa, we could change the numbers with franchisors. So it's hard to know how to measure those things. Then the other problem they had was they had 30 franchises, but the majority of their disputes came from McDonald's and Subway. So you're looking at 30, but most of the disputes actually come from a small number of franchises. So you're probably learning more about those franchises than you are learning about franchises as a whole. And that continues to be the case, because one of the things I thought about doing for the conference was just replicating their study, avoiding some of the like bizarre things like putting personal injury cases in those franchise cases. And then you start looking at the distribution of disputes. Most franchises disclose, I mean, I took a quick look at 30 franchise disclosure documents and the item 3 disclosures. More than half of them disclose no disputes whatsoever. Okay, and then you have ones like, I'll talk about Subway in just a minute, it's a huge number of disclosures. So it really distorts, it makes it hard to, again, generalize from what you're finding. Okay, so again, they recognize the limitations, which is good, which you have to do. And it's useful in sort of, again, from my perspective as someone doing research in the area, important to keep track of or keep tabs on these litigations and these limitations and evaluate how it affects what one ends up finding. Okay, so with all that background, right, there's one study out there, it's got real problems. I'm like, well, sure, what the heck? I'll see if this actually can be a useful source of data. Okay, and I probably should actually have brought the paper versions, would have been more effective. But as I said, most franchisors don't disclose anything. Okay, then you get to Subway. Okay, they disclose over 700 in a given year disputes, the vast majority of which are franchisor-initiated actions. Okay, and it's a huge franchise chain, right? There's 26,000 Subway franchised units in the United States. Their 2000, this is in the 2013 franchise disclosure document, 38 pending actions, 680 franchisor-initiated actions, and then 62 disputes that were 62 cases in which they were held liable over the last 10 years and 1 pending injunctive order. Okay, now, lots of disputes, it's kind of nice, right? If you're sort of doing empirical research, it's nice to have at least some variation. If you got lots of zeros, that tells you something, but if everybody has kind of the same outcomes, it doesn't, you're gonna have a hard time finding anything that's at all meaningful, okay? So if you sort of look at so I guess so frankly, Subway has enough disputes that they don't even do it in item 3. They have a separate exhibit at the end of their franchise disclosure document where they put all their litigation and arbitration. And for what it's worth, these are almost all arbitrations. There's a handful of court cases, but almost all of these are arbitration proceedings, which again are things otherwise you couldn't find out about. Okay, so you've got a bunch of pending actions, and this illustrates how the disclosure works for the franchisor-initiated actions. Okay, that you have an overall heading of the type of dispute, enforcement of system standards, and then some other subcategorization based on the current status of the case, and then really just a list of the case, right? So Doctors Associates versus Mohammed Ismail, and so forth and so forth and so forth. Okay. So what I decided eventually to try to do is rather than replicate, and I guess it's probably worth noting, so the first thing I put up here, there's basically 33 pages of these disclosures, and then another 17 pages of these disclosures to make up the over 700 cases being disclosed. Okay. What I ultimately decided to do, and what the rest of the paper does, is to try to see if there's empirically a way to understand or to evaluate's not the right word, to predict what sorts of factors are associated with the existence of franchisor-initiated litigation or claims or actions. Right. So if we have all these different franchisor-initiated actions, why the way to put it is, why do some states have more and some states have less? Right. What sorts of things can we try to do to figure that out? Okay. And got a bunch of possible variables that may be relevant. Right. A bunch of possible considerations. Clearly, the number of, and again, so I came at this from a state level perspective. I don't think there's really enough information to try to do this on an individual franchise. I mean, you need to have presumably one of the best predictors of whether an individual franchise is going to be subject to a suit or action by the franchisor is something to do with that franchisee's individual characteristics, their finances, their location, something. And it's really, I mean, that data is not disclosed. Okay, so at least certainly not the former or the latter. You could actually get their address, but then you'd have to figure out how to evaluate what that means and sort of somehow match it up with other data about the vicinities. So it's really hard to do this on an individual franchise level, although it'd be really nice, right, to have 26,000 observations would be great instead of 52. But so instead of doing that, I looked at it on the state level and to take a look and try to figure out or try to predict what sorts of characteristics of a state are likely to result in more claims brought by the franchisor. And just to be clear, these aren't, all I'm looking at are the claims brought by the franchisor, right? The ones where we have a sense that it's a pretty complete list, not claims brought against the franchisor. Okay, so first, sort of what I'd hope would be an obvious consideration, although based on some other studies I've seen, it's maybe not quite so obvious, is the more franchises that are in a state, you would expect there to be more disputes in that state, right? More franchises or initiated actions. If it's totally random, a state that has I can't remember what's, California's got 2,600 plus Subway franchises, Vermont has 41, just in absolute numbered terms, you would expect there to be more disputes in California, more franchise or initiated actions in California than in Vermont. So you have to control for that. Another possibility is how fast the chain is growing in a particular state. Right? If there's been a big increase in the number of franchises in a particular state, that may well result in more franchise or initiated actions. At least that was my thought, for a couple possible reasons. One is if it's growing fast, maybe the franchisor is being less careful in who they're picking and are more likely to have disputes with that franchisee. Maybe it's some sort of, if they're growing fast in the past year, it indicates they're having some problems with their current franchisees or something like that, and they're trying to make up for it by growing, by bringing in new franchisees. There may be other reasons too, but those both suggest to me that a higher franchise growth rate in a state may, in subsequent years, result in more franchise or initiated actions. The economic conditions in the state strike me as relevant. There's been a lot of empirical work showing that when the economy goes bad, there's more court cases filed, which is sort of what you'd expect, right? There's more disputes, businesses tend to go under, contracts tend not to pay off the way people thought they would, resulting in more disputes and more court cases. And so my initial prediction was that in parts of the country where the economy is weaker, the franchisees might have a harder time, right? They might not be able to make the money they were expecting. They might cut more corners or do something that the franchisor thinks is objectionable. And so measuring this by unemployment rate, states with a weaker economy may have more franchise or initiated actions. On the other hand, I mean, you do have to keep in mind here, and I guess I should make this clear, right? We're looking at Subway sandwich shops, Doctors Associates as the franchisor. It may be that cheap lunches actually have sort of counter-cyclical, right? That people who used to go out for nice lunches when the economy's good now go for cheap lunches. And so who knows, maybe Subway franchisees are doing better when the economy's bad. Now, if you look at, I mean, Quiznos is a good counterexample, although there obviously were other problems there. A downturn in the economy generally is not good for franchising as overall, and that seems to be also the case for fast food franchises, but at least some uncertainty here as to what the prediction would be. Demographic variables, so several prior studies have looked at just sort of the concentration, right, the sort of urbanization of the place, of the state, as and using it really as a proxy for the litigiousness, right, how often there are lawsuits filed. I don't know that that really applies when you're looking at one franchisor's dealings throughout the country, but it may be that if a state's particularly urbanized, okay, franchises are closer together, maybe there's more encroachment issues that come up, which might suggest more disputes with higher urbanization. Conversely, it may be that you're going to have more franchises owned by the same franchisee in an urban area, in which case they may be better franchisees, right? Because they've sort of proven themselves, they've got more at stake. And so there may be fewer disputes in highly urbanized areas. So that's another variable that can go either way. Franchise termination statutes is something that I'm glad Uri went first, because I don't have to go into any of the economics here as to what one might expect. And recognize that, I guess first of all, recognize there may be no effect at all to the extent that review websites do in fact constrain any sort of free riding by franchisees. You wouldn't really expect there to be any relationship between franchise termination statutes, the existence of a franchise termination statute, and the number of franchisor-initiated actions there are. On the other hand, if there is some sort of relationship, it's hard to know which way it cuts, right? It may be that if the statute precludes franchisors from at-will and termination, they may rely more on courts to enforce their franchise agreement, or arbitration, as the case may be. And so there may be more disputes in states with franchise termination statutes. On the other hand, the sort of standard economic prediction and empirical work prior to Uri's work, is that there's actually fewer, the effect of the statute is to reduce the number of franchise opportunities because franchisors are less willing to take the risk, and so they can't control free riding through at-will termination, so they do other things like enter into fewer contracts with franchisees. And if that's the case, there may be fewer franchisor-initiated claims if the franchisor is more careful in screening the franchisees in states with these statutes. So again, uncertain how this is going to come out, or how you'd expect this to come out. And then the final consideration is this is getting a little bit fancier than probably I should even be attempting, but looking at interaction terms where maybe, just to illustrate, it may not be across the board in states with franchise termination statutes that a particular result happens. It may be only under certain conditions, right? So if the economy goes really bad in a state with a franchise termination statute, that may result in more or fewer franchisor-initiated claims. But if the economy's going fine, it doesn't have any effect. So you sort of see how it's really taking sort of sub-pieces of some of these different variables and seeing if that makes a difference, okay? So, several variables, a number of variables, lots of uncertainty in what to expect. Okay. So then, as I've said, used item 3, disclosures as the source of data. There were 680 in 2012, 680 franchisor-initiated actions. First thing I did was a bunch of them are either Canadian or really overseas franchises, and I excluded those because I don't have any other data about what those, the conditions that those franchises were being operated in. And then the other thing I had to do, given that I wanted to focus on a state-by-state basis, is figure out what states these franchisees were in who were involved in these disputes. And, actually I had my daughter help me with some of this because she was a senior in high school who just graduated and didn't bother getting a job in time. So she's basically sitting around doing nothing all summer. And I'm like, okay, Julie, if you're going to sit around doing nothing, you're at least going to work for your dad. And so I had her help me with some of this data. And she was like, oh, this isn't working at all. I'm not finding these things. I'm like, okay, how hard can it be, right? There's a list of franchisees in the franchise disclosure document. Okay, and so all you got to do is find the name on the arbitration list, go find the name on the list of franchisees, and you know where they're at. All right, sounds really good. It didn't work quite as well in practice when she went off to college and I tried to pick up from her slack and do it myself. And there's a couple reasons why it doesn't work. The first is this is one of 157 pages in the franchise disclosure document of a list of Subway franchisees. Okay. And if you can't read it blown up on the big screen, let me tell you, you can't read it much better when you have the paper copy in front of you. Okay, so there's a lot of them. And the other problem is, frankly, another problem is the print is so small that you can't effectively search it. So I was like, well, you just type in the name and you search it and you find it. It doesn't work. And I don't know what it is about these PDFs, but it doesn't work. Okay, it doesn't work very well. So it ended up being there were 20 of these that I could never find ever. I couldn't find the name. I mean, these were people who had an arbitration or litigation with Subway, okay? Presumably they're either in this year's list of franchises or the previous year. I couldn't find them anywhere. Now, maybe they're Canadian. At least one of them I was able to confirm was Canadian, so that may be why I couldn't find it, okay? But that was one problem, and it made this take a lot longer than I thought it should have. The second problem, in the first draft of the paper, I called this the Patel problem, and I thought maybe that's going to sound racist in some way, so I changed the name of it, okay? The problem is, if you have Doctors Associates versus so-and-so Patel, all right, you would be amazed how many Subway franchisees are named so-and-so Patel, okay? That in fact, there were 40 disputes, 40 actions brought by franchisors against a named franchisee where there were multiple franchisees in different states with that name. Okay, maybe it's the same person. I think some of there was one franchisee one name of a franchisee who had franchises in Maryland, DC, and Virginia. That may well be the same person. Okay, but there were others that were all over the country. Clearly, this is just a common name, and it's not a problem I anticipated at all. But that meant another 40 of these I couldn't even tell what state they were from. Okay, so it's potential bias in the results. Okay, so quick overall numbers. Okay, these are the absolute numbers of actions brought by Doctors Associates against franchisees. New York, not surprisingly, well, maybe surprisingly. It's one of the five states with the most franchisees, or most franchise locations. And New York had most disputes of anywhere. Pennsylvania, Illinois, and California came in fourth in the number of disputes. Okay. What I wanted to do, what I ultimately ended up doing was to control for the size of the state, the number of franchises in the state, was to basically try to figure out or try to predict what percentage of franchised units in the state had disputes. Okay. And here, interestingly, New York is still up there pretty high. I think it was second. Vermont actually had the most franchisor-initiated actions of any state in the United States in 2012. They had 2, because they have very few franchise units. The 2 actions were enough to give it the highest percent. Okay, so that was what I used as my dependent variable, what I was trying to explain, and then ran some regressions to try to figure out which of my sort of theorized variables might actually explain what happened. Okay. Unemployment rate, well, I should say, really the last thing up here is probably the first point to make, and that is there was a huge amount of variance. The vast majority of variance was not explained by any of these variables, okay? Which means I had a really crappy model, I guess, which means there's probably not a lot of reliability to any of these results, but it certainly means it's hard. There's a lot that goes on in trying to predict when there is a franchisor, going to be a franchisor-initiated action that isn't explained by the types of things that I thought might explain it. Okay. Of the things that I thought might be relevant, turned out unemployment rate, economic conditions, didn't find any significant results. The growth rate of the franchise system in the state in the previous year, in and of itself, nothing significant. Interestingly, the urbanization measures had different results depending upon which one you used. So if there was most of the population of the state was in an urban area, that was correlated with fewer disputes, which would be consistent with the idea that maybe there's a lot of common-owned franchises in those areas. But if you looked instead at the percentage of the state that was urban by geographic area, which tended to highlight sort of small states, right, small, highly populated states, tended to have more disputes in those states. And that may be some sort of regional effect, I suppose. There's a lot of northeastern states very, very high on this urbanization measure. The mountain states where there's very few people and lots of open spaces tended to fare very low on this measure. I guess what I will conclude with is sort of going back to the discussion this morning of Uri's paper. There was a very weak, but at least occasionally statistically significant relationship between the existence of a franchise termination statute and the frequency of claims brought by the franchisor. And if you had a franchise termination statute in the state, as a general matter, it tended to be negatively related to the number of, or the proportion of franchisor-initiated claims. So you had fewer of them, okay? However, one of these interaction variables looking at the growth rate was also significant, and it had a positive correlation. So really what this boils down to is if you're in a state with a franchise termination statute and there's been a substantial growth in franchise units in the previous year, you tended to have more franchisor-initiated claims. Okay, if there was a much slower or zero growth, you tended to have fewer. Okay, and again, it sort of suggests a complicated relationship between the franchise termination statutes and the extent of franchisor-initiated claims, where, again, if it's sort of a stable environment, there may be fewer, perhaps suggesting that the franchisor is being cautious, but if it's really growing fast, it suggests there may be some increase in the proportion of franchisor-initiated claims in jurisdictions with franchise termination statutes. All right. What I want to just, my closing comment, I simply want to say is this is totally about subway, right? I mean, I talked before about the importance of being cognizant of how representative your sample is. This is one franchisee, and it's a franchisee that has way more franchisor-initiated actions than any other franchise I looked at. So you have to be really careful about trying to extrapolate from this one franchise to any significance, frankly, about other franchisors or other franchises. But I guess I will say, the way I kind of conceived of this was as a sort of proof of concept idea. Is it possible to do something with the item 3 disclosures? I think there's serious limitations to those disclosures, but it may be possible for researchers to do more than they are doing with those disclosures. And with that, I will stop. Do we want to do some questions? Okay. Was Uri first? You guys decide. Whoever talks first, I'll answer.
Thanks. Okay, so question. What in your opinion are the normative implications of these findings? Are there any normative implications to these findings? Do you think that the law should be shaped in a different way than it is because of these findings? That's the first question. And the second question is, did you think about taking into account two interesting variables? First of all, the number of single-unit franchisees and multi-unit franchisees in the state. Because if you have many multi-unit franchisees, then the risk for dispute is lower than if you have single-unit franchisees. And the number of franchisees who joined the association. If there is an association, an effective association, many franchisees join the association, then maybe the percentage of disputes will be lower because the association protects franchisees.
Yeah, no, those are both absolute. Those are great suggestions. I don't think the data is available on either of them. I certainly haven't seen state-by-state membership. I'm not even sure if, I can check on whether I can find those for Subway, but, and even on them, I don't think the multi-unit versus single unit, well, put it this way, the multi-unit versus single unit, the one way I could try to do that is go through those 157 pages, and it's a good suggestion. It's just really hard to implement because there's no separate listing of in New York there are this many multi-unit versus this many single unit. My best answer on that part of it is that I'm using urbanization rate as a very, very rough proxy to capture that, but it's very, very rough, and I wish I could do that. That one in particular I think is exactly right, and the association one is too. I just don't know that I can get that one. I'd be surprised if I could get the data. On the normative side of it. No. I'm not sure there's good or bad in sort of the number of, it's more just trying to understand, I guess my view on it is just trying to understand how the world works. So, if you have normative suggestions, I'm certainly open to incorporating that possibility. But it's, I saw the project more as just trying to understand why, under what circumstances franchisors, or I guess more specifically doctors' associates, is likely to bring claims against its franchisees. Maybe I'm not sure that there necessarily even are normative considerations or normative implications. Because really, the number of disputes isn't per se, it's not like it's bad or good, it's just more understanding. That's my thought anyway. But again, I'm open to suggestions on normative stuff if you haven't. Phil?
A caution and a suggestion. The caution, you admirably, extremely candid about the considerable number of caveats. You could be wrong. But there also are some caveats that don't show up in traditional ways.
Okay.
One of which is that Subway is unique. They probably have more franchise-or-initiated actions than the rest of franchising combined.
That's a fair bet from what I've seen.
They are an extremely aggressive company. That's their business model. Is they sue at the first date, and it shows up in the figures. And if Jack Dunham were well, and he's not very well, but if he were, he's a lawyer. He could tell you that's what they do.
Yeah.
It was really hard to draw much.
Yeah, I agree absolutely, but that's good.
But they also have an intellectual. They have a smaller percentage of multi-unit franchisees than most.
Okay.
Much more of their business is one-on-one than other franchises. So it's hard.
Okay.
But now a suggestion, and this is for all of you academics who are more likely to do this than we are. There are some interesting things that could be done in terms of trying to draw information from available information about franchising and its relationship between the business side and the legal side. And I'll give you one example which didn't work. But I became interested in whether or not the influx of more franchisors into the business would have an effect upon what the ultimate litigation and disputes would be. Okay. Because we had a period of 2005 through 2008, when there was a huge influx of franchisors. Many more registered for the first time in that time period than before. And I also took a look at what can we tell, because we can, from their capitalization. And they were far and away less capitalized than the previous period of time. Second, which one said it was the first time that they opened, that they started franchising before they had a single company-owned unit. And there were many more as a percentage of that. So my theory was that the gene pool is being diluted by weak, undercapitalized franchisors. At the same time, franchisees are larger, capitalized, more educated, and therefore more prepared to take on litigation. I thought that would lead to more litigation in franchising 2 years or 3 years after that. All nice and well. But it didn't take into consideration the fact that the recession that followed had a dampening impact on litigation generally. People just concluded they would do anything rather than pay legal fees to fight these battles. So all these nice theories didn't work out. But there is a huge amount of data that you can get for those academicians who are interested in doing these. There is an organization that you may know called Brand Data. And Brand Data takes every filing by every company, every franchise company, and can turn that data, whatever there is there, they can pull it out. And I think that some of you folks ought to take a look at whether or not you can draw some conclusions and perhaps public policy recommendations out of it. Sorry for the long.
No. The recession screwed up a lot of things, most of which were much more important than my research undertaking. But that period, and really, I mean, this is 2012, so we may have gotten so far. It's not like we fully recovered, but this is late enough in the cycle that it may have overcome the sort of initial reluctance to litigate, but it may be far enough along that it's whatever that effect has been missed. But
I don't think the government was ever deterred.
and we could check that, right? Because we can get their FDDs back for a while. But appreciate the suggestion, and the idea of more empirical. I think empirical work is a great thing. So, from my perspective, as long as we can have arbitration linked to it, I'm happy to do it.